While the definition of torture under the Convention does not include pain or suffering arising from, inherent in, or incidental to lawful sanctions, this limitation has been interpreted restrictively. A sanction considered lawful under national law may still constitute torture or other prohibited ill treatment if it causes physical pain or mental suffering. In this regard, the prohibition against torture and ill treatment extends to corporal punishment, including excessive chastisement ordered as punishment for a crime or as an educative or disciplinary measure. All states parties are obliged to submit regular reports to the committee on how the rights are being implemented. States must report initially 1 year after acceding to the convention and then every 4 years. The committee examines each report and addresses its concerns and recommendations to the state party in the form of concluding observations. In addition to the reporting procedure, the convention establishes three other mechanisms through which the committee performs its monitoring functions. The committee may also, under certain circumstances, consider individual complaints or communications from individuals claiming that their rights under the convention have been violated, undertake inquiries, and consider interstate complaints. Issues considered by the committee in practice regarding the prevention of torture and ill treatment. The use of prolonged solitary confinement, the use of incommunicado detention, the length of police custody or pretrial detention, poor conditions of detention, including the lack of basic amenities and services, appropriate medical attention, poor hygiene, violence, and sexual abuse. Corporal punishment, excessive use of force by law enforcement officials, acts committed by public officials by acquiescence, including violence by private parties, such as corporal punishment in the family and private schools, domestic violence, human trafficking, hate crimes, female genital mutilation, interprisoner violence in detention. Misuse of psychiatric hospitalizations, women in detention, juveniles in detention, death in custody, and enforced disappearances. Issues considered by the committee in practice regarding non-refoulement. The adequacy of appeals mechanisms in expulsion procedures, ensuring that public officials receive specialized training or instructions on Article 3 related obligations, the use of diplomatic assurances or guarantees as the basis for carrying out refoulements, extraditions, and expulsions, ensuring that jurisdiction for Article 3 extends to all areas under the de facto control of states parties, non-refoulement for individuals sought for acts of terrorism, enacting asylum legislation in a national asylum system, ensure that proper screening and individual investigations take place before proceeding with expulsions or deportations, issues considered by the committee in practice regarding the criminalization of torture. Introduction of a separate crime of torture in the domestic criminal law of the state under review, introduction of definition of torture in line with the convention, appropriate penalties for the crime of torture, minimum age of criminal responsibility, guaranteeing fundamental legal safeguards for detained persons, statute of limitations on complaints of torture. Issues considered by the committee and practice regarding universal jurisdiction. The implementation of legislative measure for the establishment of universal jurisdiction, the use of immunities and amnesty laws, state obligations to extradite or prosecute persons alleged to have committed torture, the failure to conduct preliminary inquiries, the obligation to remove any legal obstacles to the extradition of torture suspects, information about mutual judicial legal assistance. Issues considered by the committee and practice regarding training officials and reviewing detention procedures. Regular training of all relevant personnel in the provision of the convention. The provision of anti-torture training on all aspects of the convention, including the need to raise awareness of gender-specific issues such as sexual violence against women and discriminatory practices against vulnerable groups. The establishment of regular and independent inspections of all places of detention, including access to NGOs, and improving material conditions in all places of deprivation of liberty in line with the Nelson Mandela rules. Remedies for victims of torture, the right to complain and the right to redress. Article 14 establishes an obligation to provide victims of torture with an effective remedy and an enforceable right to fair and adequate compensation. Article 14 is closely related to Article 13, which requires states to ensure that victims of torture have an effective right to complain to a competent body without fear of reprisals. States are required to investigate each case promptly and impartially. Article 13 aims to establish the facts and therefore constitutes the basic remedy for torture victims. The committee has considered that such remedies for victims of torture, including the right to redress, should be applied to both torture and ill treatment. Particularly, issues considered by the committee in practice regarding the right to redress includes failure to recognize survivors of torture, including survivors of sexual violence, as victims of conflicts, difficulties in obtaining redress for victims of torture, delays in complying with reparations awards, and implementing a legislative framework and procedure enabling all victims to enjoy their right to redress. The committee also clarified that redress includes the five forms of reparations. Number one, restitution, reestablishing the victim to their situation before the torture was committed, taking into consideration the specificities of each case and including the structural causes of the violation, including any kind of discrimination. Number two, compensation. Monetary or other non-monetary compensation given to the victim for any accessible damage resulting from torture or ill treatment. This may include medical and rehabilitative expenses, loss of earnings and opportunities, and earning potential due to disabilities caused by the torture or ill treatment, legal assistance associated with bringing a claim for redress. The committee has made clear that the provision of monetary compensation on its own is not sufficient for states to comply with their obligations under Article 14. Number three, rehabilitation. A full holistic rehabilitation, including medical and psychological care, and legal and social services to restore a victim's independence, physical, mental, social, and vocational ability, and full inclusion and participation in society. Number four, satisfaction. This includes the verification of facts and public disclosure of the truth, an official declaration or judicial decision restoring the dignity, reputation, and the rights of the victim, effective measures to stop the violations, assisting in the recovery, identification, and reburial of victims' bodies, public apologies, including acknowledgement of the facts and acceptance of responsibility, commemorations, and tributes to victims. Lastly, guarantees of non repetition, measures taken to combat impunity for violations of the Convention. The issue considered by the committee in practice regarding Article 15 or the exclusionary rule is to introduce legislation to specifically outlaw coerced confessions or evidence obtained through torture or ill treatment.